without Section 33, there is no charter. And the goal of Section 33 was always understood for two things. It was understood as a way for legislature to provide an alternative interpretation to rights. And another thing that was in the framer's mind is that we have a list of rights and freedom, but what about the other rights that are not listed? Like economic rights and liberties, for instance, which have been excluded from the Charter, are infringed in a manner that creates issues for the common good of the people involved. The reality is the Section 33 is actually a rights and freedom saving provision, not a rights and freedom infringing provision.
What is a Canadian?
Protesters here to tear down
a global trend in decline.
Canada is in the middle of an
across the
housing
country.
crisis.
Welcome to Inside Policy Talks, the podcast in the Macdonald-Laurier Institute. I'm Peter Copeland, Deputy Director of Domestic Policy here at MLI. Today, we are here to discuss a major constitutional showdown now before the Supreme Court of Canada, a record number of interveners in quite possibly the biggest and most consequential case since the Charter was adopted in the 80s. At issue is Hack versus Quebec, a case that goes to the heart of the scope of rights and their limits, whether the Notwithstanding Clause is subject to any bounds beyond proper application, and the balance of power between courts and legislatures. Many, I think, are tempted to view the case through the lens of the content of the laws at issue and whether they are right or wrong, but the stakes are far greater. The case is really a question of who decides what the law means, how is it interpreted, and ultimately changed. And however the court rules, the decision will shape Canadian politics for years to come. At MLI, this is central to our Judicial Foundations project, where we examine how courts, legislatures, and constitutional principles interact in Canada's parliamentary democracy. And these cases really raise fundamental questions about whether the balance is being maintained or fundamentally altered. And joining me today are three leading voices on these issues. Yuan-Yi Zhu is a professor of international relations and law whose work focuses on constitutionalism, public law, and the limits of judicial power. He is a member of the University of British Columbia Okanagan's Constitutional Law Research Group and our own Judicial Foundations project. Xavier Foucault-Ménard is a lawyer at Stikeman Elliott, a legal scholar specializing in constitutional law, rights adjudication, and the theory of the Charter, and also a member of Okanagan's Constitutional Law Research Group. And last but certainly not least, we have François Côté, who is directly involved in the case as an intervener for Droit Collectif de Québec, a lawyer and a lecturer in law at Université de Sherbrooke. He's bringing a practitioner's perspective to the discussion. And before we begin, I want to remind everyone to please like and subscribe, as that really helps us reach more people with these important ideas. So thanks to the three of you for joining us today. So I want to start at a high level. What's actually at stake in the case here? Can you briefly walk us through Hack versus Quebec and its significance, I think?
It all started back in 2019 when Quebec adopted the Loi sur la laïcité de l'État, Bill 21. We'll refer to Bill 21 for brevity's sake from now on. But in 2019, Quebec adopted Bill 21, which applied a few obligations of religious neutrality to public servants. So it's a piece of legislation that entails that in the accomplishment of their duties, several public servants should abstain of wearing religious symbols when they're in office, when they're accomplishing their duties. Now, the merit of that very specific law is, we'll put it in parentheses here because it's actually not the main issue that was contended in front of the tribunals. That law, Bill 21, was also protected by a reference to what we call the Notwithstanding Clauses, sections from the Quebec Charter and the Canadian Charter, both charters were invoked here, which set aside the power of tribunals to analyze and adjudicate adjudicate on the validity of the law as per pertaining to some charter rights. So it was enacted by the legislature that the Bill 21 was going to apply regardless, notwithstanding the Quebec Charter and sections 2 and 7 to 15 of the Canadian Charter of Rights. And it has been made upstream preemptively before the law was presented in front of any court, which, as we will have the occasion to talk more later on, is not inconsistent with Quebec long-standing practice on that effect. It has been done like over 100 times. But the idea that this law should be protected by the Notwithstanding Clause and be outside of the tribunal's scope of invalidation in and of itself, it is at the core of the judicial conflict. From the trial level at the AC case, then it became the I forgot the name it took at appellate level, and then at the Supreme Court when it became English Montreal School Board against Attorney General of Quebec. It was always the same question: can the National Assembly of Quebec actually invoke Notwithstanding Clause here to subtract the law from the scope of judicial invalidation? And there were two competing voices. On the one hand, there were the opponents to the Loi sur la laïcité de l'État against Bill 21, which were saying roughly, and I will let my colleagues elaborate on that, but which were roughly saying that no, the legislature cannot use the notwithstanding mechanism in a preventive matter before it has been adjudicated. And other argument, it could not use the notwithstanding mechanism to contravene some core elements of rights, some constitutional architect principle of the Canadian Constitution. And on the proponents of Bill 21 and on the defense side of the Notwithstanding Clause and the parliamentary sovereignty, that's another name for it, they were pleased that the constitutional architecture in and of itself is actually a balance of power between the legislature and the tribunals. And in a democratic society, the final word, even to such sensitive issues, should be entailed to the elected legislature. And it also stems from the fact that the jurisprudence is not neutral in some aspects, and the legislature should have a right to disagree with the tribunals as to the very nature. What do those fundamental rights mean? So it's not necessarily the fact that we as a legislature recognize that this law violates fundamental rights. No, it's we disagree with the tribunals, with more specifically with the Supreme Court of Canada's interpretation as to what those rights mean and how do they work. And we are stating, as the Notwithstanding Clause allows us, that has allowed us since 1982, we are saying that this question should not be quashed by the courts. It's a matter that should, as the Constitution allows it, that should be reserved to the legislative prerogative. And it went all the way to the Supreme Court, and the case lasted at the Supreme Court level for about a year and a half of internal procedures until it finally boiled down to one of the largest pleadings of this century, and probably one of the largest of the Federation's history, in which we had more than 116 counsels during the hearings last week, over 40 interest groups, the attorney generals of many provinces, including the federal, and notwithstanding the parties themselves. So the hearings lasted for 4 days, one of the longest in history, in which both sides presented their arguments, and with in some cases very voluminous factums. So it was an incredibly rich experience, lots of debates, and especially lots of very, very different perspectives as to not only what's the scope of our rights and freedom, but what's the scope of our federation? How are powers supposed to be adjudicated? How do they work? And what kind of democracy are we living in? Those were the kind of questions that were debated last week.
Yeah, well, we thank you for being here after what must have been quite a grueling bit of preparation and and
That's an
work.
understatement.
Yeah, yeah, and as some commentators have noted, kind of like a mini parliament in the number of interveners there, and that's something certainly that's a theme here. Like, is this the court veering too much into the legislature's domain? And one thing I want to pick up on that you said, Francois, that really gets to the core of the disagreements here between different parties is this conception of, is invoking the notwithstanding clause somehow like outside of the charter, and a recognition, an admission that the its use is a rights violation, or is it contributing in the legislature's role to a kind of the interpretive function, saying, this is in fact how we think that the right should be interpreted and balanced against others. And so we'll come back to all of that. But before we move on, Yuan and Xavier, I'd like to hear from each of you if there's anything else you'd like to add about specifics of the case, or why you think it's important.
I'll go first. Thank you for having me, and thank you to Francois for his very comprehensive summary. I think what he said at the beginning is really important, right? There's hack as the facts of the case, the facts about the Quebec law on church and state, and there is the bigger issue here of Section 33, and I think it's very important to really distinguish the two because many people disagree with the decision of the Quebec National Assembly to pass this law. Actually, cards on the table. I don't like the law. Had I been a member of the legislature, I would have voted against it, right? But that is what But we do live in a democracy, and the case is really about broader issues of essentially, if you want to simplify this a bit, who gets to decide in the end, right? So we have a system which is mixed. In terms of the constitution, right? We have a parliament and the provincial legislatures which make law, but increasingly lawmaking has really shifted to the courts. And you mentioned, Peter, that there were dozens and dozens of interveners, right? And Francois said there were hundreds of lawyers. And I think this is very emblematic of the new Canadian Constitution under the Charter, where any law which is remotely controversial has to go to the courts because we have accepted um, implicitly that since the charter was enacted, courts have the final word on what is allowable and what isn't. And this has been the sort of a state of equilibrium in Canada, in politically speaking, for many decades. And I think we're really beginning to see this equilibrium break down because the Supreme Court and other courts have been handing down decisions which are frankly indefensible in terms of how they match with the text of the Constitution, right? In all sorts of areas, especially criminal justice, but also in other areas. And I think we're really seeing now that uh, legislatures, premiers, politicians are really becoming more aware of the fact that at the end of the day, they do have the right to override the interpretation of the charter as propounded by the judges through the notwithstanding clause. And many of the interveners in this case, in Hack, are basically trying to establish new doctrines whereby legislatures would be limited in their ability to use the notwithstanding clause, for instance, by limiting its preemptive use, or by saying that actually there are limits which are not written in the Constitution, and so on. And so this, I really think this is a case about what the Constitution says, and does the Constitution mean what it says as written down, as agreed upon by the premiers and the federal government in 1982. It's really about the bargain which we struck when the Constitution came back from Westminster, and I think many people are really pushing for this bargain to be broken because without the notwithstanding clause in 1982, there would be no charter, there would be no 1982 Constitution Act. This was a part of the fundamental compromise which Pierre Trudeau had to agree, because premiers would not agree to his entire scheme unless they had a way of overriding the interpretation of the charter by the courts. And that was the compromise. And I think we are really seeing attempts to really break that compromise through the courts.
Yeah, wonderful. Xavier, anything to add?
Yes. So I think what Yuan and Francois said is correct. I will also add maybe a reflection on this on both. So I agree that the best summary and the best question here to answer is who decides. One thing that I will add to Francois' summary, though, is that it's not just about whether the courts can intervene and declare and has something to say on when Section 33, so the notwithstanding clause, is being invoked, in my view, but it goes slightly further than that. It's also whether the protections that are granted by the Charter under Section 2 and then 7 to 15 actually apply. And we have also, and I think Yuan is correct, that we tend to resolve any controversial law, any issue through the courts and tribunals. And the reason why we do so is we have to recall that there are built-in effects in the Constitution of Canada when a law, ordinary law, is deemed inconsistent with the Constitution. And so the reason why we tend to go through the courts all the time to resolve these issues, especially pointing to the charter rights, is because we have Section 52 that says any law that is inconsistent with the charter or with the constitutions, which includes the charter, becomes invalid and of no effect. So the whole process here of going through the tribunals is mostly to achieve this effect of invalidating the law that is deemed problematic. But that only works insofar as the actual provisions apply, the charter provisions apply. And so you're only able to say that a law that a law is inconsistent with the charter rights if the charter rights itself applies, is in effect. And I think part of the issue here is that when you invoke Section 33, it's not just that you remove the tribunal's right or jurisdiction, I would say, to declare or intervene on the interpretation. It's even more than that. It's that you're saying the ordinary law operates notwithstanding the charter rights targeted. So that means the charter rights, and it's not even the charter rights. If you look at Section 1, the provisions actually guarantees the rights and freedoms. So you're not inconsistent with the rights or the freedoms per se, but you would be inconsistent with the guarantee of these rights and freedoms. But then by the effect of Section 33, you're even removing this part because Section 33 says the ordinary law applies notwithstanding. So the guarantees of rights and freedoms don't even apply. So it's not just that we're removing the tribunals the right to say something, it's that they cannot say anything because there is no applicable law that allows them to say to declare an inconsistency.
So
if I may just add one last thing before we move on to the next subject, I agree with everything that was said prior. And I would just like to add one more thing. Let's never forget that Section 33, the notwithstanding clause from the Canadian Charter, is part of the Constitution. The Constitution itself envisaged that mechanism. So there is an argument that says, well, it's removing part of the Constitution. Well, it is part of the Constitution. So it is part of that compromise. I just want to put it on the table for the rest of our discourse.
Yeah, that is something that is often stated as though it's somehow, other than and apart from the charter, but it is very much a part. The comment you made, Xavier, about Section 52 and that inherent conflict, between the charter and a law, and then requiring, empowering the court to make a decision and invalidate this really this makes me think of Yuan over there in Oxford, across the pond, and the differences in the constitutional structure in many pure jurisdictions who don't have the same, like, courts can review the different degrees of judicial review, but I think that's an important point, that here in Canada, with the adoption of the charter, they have strong powers of judicial review that goes all the way to invalidation. And so that is why I think, to a certain extent, through the drafting of the charter, these different elements were introduced to balance some of the additional powers that were being created through it. So we'll return to many of these issues, but I want to drill down into the specifics of the case a bit more. There are many important interveners in the case, but the federal government's intervention really made a splash when it was released in the fall of last year. They have a very ambitious, into some troubling factum. I'd love to hear another good, succinct summary of what they are advocating for, and then some discussion of your thoughts on it. Francois, would you like to begin with that?
Let's do that. Ambitious is a word to describe the federal attorney general's position. Let's stick with that. Basically, the Attorney General, through some creative metaphors, when you're saying that using the Notwithstanding Clause would make society vulnerable to summary arrest and execution, would bring back the death penalty or slavery, that's a bit strong on the argumentative side. It's in some respect, it's like saying, well, if we don't shackle your hands, what's going to prevent you from committing murder? I have a bit of an issue with that argument. But back to the substantive, and let's not dwell too much on the form. Basically, the Attorney General is trying to argue that the Notwithstanding Clause should be subjugated to kind of an Oakes test. A measure of reasonability of its use, so that it could. Let me rephrase that. The Notwithstanding Clause should be, when it's used, should be able to be evaluated by the courts to see as if it's been used for a reasonable purpose. And underlying that was that there's some core of hard fundamental rights that could not be infringed even by using the Notwithstanding Clause, because it would cause, quote, irreparable harms. But there's a problem with that. And the Attorney General also invokes the constitutional architecture of Canada in the effect that using the Notwithstanding Clause to enact some legislation that would go against some of those core fundamental rights would entail a result that would go against the values or the foundations of the Canadian charters, which would be unconstitutional in and of itself. Now, there are many points of contentions regarding that. Okay, first of all, the Notwithstanding Clause is part of the Constitution, and it is part of the constitutional architecture, and there has been no definitive argument to prove that the Constituent's intent in 1981 was actually against using the Notwithstanding Clause in such a manner. There were arguments saying that, no, the Constituents did not intend for the clause to be used in that manner, but the absence of proof is not the proof of absence. There are no historical elements to prove that the constituents did not want the clause to be used in that manner, and yet here it is. But there's also another issue with that, is that the Attorney General's position would be basically to render the Notwithstanding Clause meaningless or effectless, because if itself, it must be subject to an analysis of its reasonability by the courts, just as the underlying law, which it is meant to protect, then if the clause is used in a reasonable manner for a reasonable legislative objective, then it's useless. It's futile, because the law in and of itself would have passed the Section 1 analysis under Oakes. But if the use of the notwithstanding clause is deemed unreasonable and then set aside so the underlying law can be set aside, then the notwithstanding clause has no effect. So either interpretation makes it so that the notwithstanding mechanism is either futile or powerless. But there is one thing: the legislator, and that goes for the constituent as well, does not speaks for nothing. The notwithstanding clause is in the Constitution. And both those interpretations are basically trying to, in effect, deprive it of its effectiveness. And I'll conclude on that. And the Attorney General of Canada espouses the position as if the use of the notwithstanding clause could only have the effect or the intent, either, of denying fundamental rights. And well, for the Attorney General of Quebec, for Droit Collectif Quebec, which are represented, and for the Attorney General of pretty much all the provinces, that's not the only way to see it. There is, let's not forget, we are in a federation. Canada is a federation with a centralized judicial system, but decentralized provincial powers. And the use of the notwithstanding clause, and it has been a huge deal for Quebec for the last 40 years, is that provinces, the provincial states, may have a different viewpoints than what the federal institution, the centralized institution, think of, what they interpret about the meaning, the scope, the reach, the nature of those fundamental rights. And using the notwithstanding clause is not a way of saying we are suspending or negating those rights. It's a way of saying we, as a distinct provincial state, disagree with the centralized interpretation of the tribunals, and we do not want our legislation to be quashed by an interpretation to which we do not agree. We see things differently, and we do not want those laws, which has been adopted by a democratically elected assembly, to be quashed by a centralized power on which the province has very little, if not no, say.
The issue is that in 1988, the Supreme Court decided in Ford and Quebec Attorney General that the limits to the use of Section 33 are essentially procedural, right? If you read the text of the clause, it says you have to invoke it, and once you do so, it lasts for 5 years, and it only applies to certain clauses of the Charter. And what the Supreme Court said in Ford in 1988, which also was a Quebec case having to do with French language laws, was that those are the only limits to the invocation of the clause. They are procedural, and as long as a legislature fulfills all of them, that's fine. And the Supreme Court is at liberty to depart from its precedents. They should have a good reason to do so, but often they don't really. But I think the fact that there is this landmark case decided in the early days of the Charter, which says that the limits to the Charter's invocation are procedural, makes it a bit more difficult for opponents of Section 33 to really make the extreme case they want to do. So if you read the factum of the Attorney General of Canada, right, it's actually quite hand wavy, right? It's full of hypothetical examples of, what if Quebec bans religion, or what if somebody introduces slavery, and then it says, actually, we don't really believe this is going to happen. But essentially, I think if you read between the lines, they know that they can't actually say, got the clause directly. So they have to get to the results they want to achieve indirectly, and that is really what I think what Francois was getting at, right? If you read the bits of the Attorney General of Canada's factum in isolation, you say, well, if I were to redraft the Constitution, this seems actually, maybe this seems reasonable and so on, maybe not. But if you take them together, it's really an attempt to do indirectly what they cannot do directly, which is to get the effects of Section 33 to a point where it becomes essentially unusable in practice. And just a very quick point, I think it's very important that this case did come from Quebec, right? Quebec has always had a very ambivalent relationship to the Federation, as we all know, and especially to the 1982 Constitution. Many people in Quebec don't accept the validity, moral or legal, of the 1982 Constitution. When I was a kid growing up, people still spoke about how Trudeau wickedly imposed a legitimate charter. So I think that the fact is that this case comes from Quebec and not the from Saskatchewan, where there's also a case about transgender rights and so on, actually makes a huge difference because it being from Quebec and Quebec having a special relationship with the rest of the country, the federalism element really comes to the forefront. Quebec is a distinct society. It views itself as having certain value systems which are not necessarily shared by the rest of the country, whereas the Charter, of course, is a very homogenizing instrument. And so I think we can't really understate the fact that this case has very strong political implications for Quebec and obviously as a result of that for the country.
Yeah, and you certainly see that through the consistency in the interventions from the other provinces. Yeah, Xavier.
Yep. So I think you're right, Peter, that not only did the Attorney General of Canada made the argument that François was describing, but they also made other arguments, right? So they talked about the preemptive use of the Notwithstanding Clause, which we have briefly discussed, but it's like a beast in itself. And they also made the argument about Section 28 of the Charter, which is the section that guarantees the rights without discrimination between male and female. So if we want to address these two arguments briefly, because I still think they are important. So on Section 28, there's been a lot of debates on this, and most people who read the section and have understood the section historically is that this is an application disposition. And what I mean by this is if you read the text, it says that the rights and freedom referred to the Charter are guaranteed equally to male and female persons. And so this ties back to what I was explaining earlier about when Section 33 is invoked, it removes the application of the guarantees. And so if you remove, through the use of Section 33, the guarantee of rights and freedom in specific provisions, then by necessity, Section 28 just doesn't apply, because the rights that have been guaranteed also don't apply. And so Section 28 and Section 33 are honestly of the same category, because they are both application disposition. But Section 33 just tells you that the guarantees in specific section don't apply. So that's, and there are good scholarly articles on this. Jesse Hartery has written a very good one. Highly recommend that people read it if they are interested. On the preemptive use, I will just say, I will just tie it back to what François was describing on the original intent of Section 33 and also the compromise that Yuan was describing. Without Section 33, there is no charter. And the goal of Section 33 was always understood for two things. It was understood as a way for legislature to provide an alternative interpretation to rights. I have written articles about this as well, explaining in greater details. And another thing that was in the framer's mind is that we have a list of rights and freedom, but what about the other rights that are not listed? What if by interpreting legislation compared to charter rights and freedom, we end up having an issue where other rights and freedoms that are not listed, like economic rights and liberties, for instance, which have been excluded from the charter, are infringed in a manner that creates issues for the common good of the people involved. And I think those things all of this need to fit together. But the reality is the Section 33 is actually a rights and freedom saving provision, not a rights and freedom infringing provision. And this this is because we are in a democracy. We're able to debate these things. We're able to reason about legislation and rights. It's not just the judges who are able to do that. And sometimes they do it in less quality than other non-jurists are able to do. So we need to be able to account for all of this together. And so this is what Section 33 does. So when it comes to preemptive use, the argument is that the no limits except procedural limits should always apply, and that's because we have a view of what the Supreme Court jurisprudence is on the different rights and freedom. We know how they think about these rights, but we also know how they don't think about the rights, and we also know what they don't know, and we also know what they don't look at. And this is very, very important for the legislature. It's very important for the people being governed. This is why we discuss these things during elections. This is why it's been the main and the key component of the charter for us to be able to have a charter. Mm-hmm. So, yeah.
Oh, well said. And so, rounding out the discussion of the case here, let's move to the different groups of interveners. We better group them because there's over 100. Who are the key players, and what stands out about the arguments from the provinces versus the advocacy groups? There are national unity issues. There are arguments about the extent and scope of rights. And as you were just saying, Xavier claims that certain sections of the Charter and Constitution limit, in fact, the Notwithstanding Clause either implicitly or explicitly. So you mentioned Section 28's equality protection. There's also Section 23, the minority language education rights that's being put forward by English Montreal School Board. And then a claim that Section 96 of the Constitution, it provides that the jurisdiction of superior courts is undermined by the clause's repeated use. So, walk us through the different groups of parties. If we can group them by the positions they're taking, and kind of what's at issue there. And just to reverse the order here, let's hear from Xavier and Yuan first, and then we'll go to Francois.
Right. Thank you. So it's a bit of a burdensome task, but I'll try to do a mapping so that it's a little bit clearer for everybody. So let's take a step back. This case comes from the Quebec Court of Appeal, in which the Quebec Court of Appeal basically gave right to the Attorney General of Quebec and said that the Loi sur la laïcité, so Bill 21, was saved and constitutional, in part because of Section 33. And this was appealed, right, by Hack, which was the main person involved, who was wearing a hijab. I think she was a teacher. And then you had the English Montreal School Board involved as well, and we had we had some other related parties who went on this side as well. And the amount of interveners, I would say, I don't recall exactly how many you said, like 60 something, but most of them kind of fall in this category because they were supporting the Hack and English Montreal School Board. So these people, because they lost, so to speak, at the Quebec Court of Appeal, these are the people who are the appellants. And then on the other side, you have the defendants or respondents in this case, those who won again at the Supreme Court, at the Quebec Court of Appeal. So that was the Attorney General of Quebec, Jean-François Roberge, Simon Jolin Barrette were involved, and then Mouvement Laïque Québécois as well. And okay, and so that's basically the mapping. I may get some of these facts wrong, but generally that's what it looks like. And the arguments from the appellant side is generally what we've been discussing, right? So can you make declarations? Can you make judicial declarations even when Section 33 is invoked? Is Section 33 saved from Section 23 and Section 28? So and the arguments that were brought forward by the Attorney General of Canada have been used and brought forward by other of these appellants as well. On the other side, from the respondents, these people are trying to, of course, have the Supreme Court uphold the decision at the Quebec Court of Appeal. So these people generally are relying on, of course, on a exclusive and full application of Section 33, as was decided in the Ford decision, which Yuan mentioned. So that means that the limits on the use of Section 33 are only of procedural nature. If you check all the boxes, then Section 33 applies exclusively and completely, with no possibility for, because the rights are and freedoms are being rendered inapplicable by its use, which also means the tribunals have nothing to say on them. So that's the main argument. But then we've seen a lot of different arguments explaining the different customs in Quebec, the way that the Constitution was negotiated and brought forth, the way, and François can speak about this, but how the Section 33 clause is basically a sovereignty, parliamentary sovereignty saving clause, which is very, very important for governed people to be able to be sovereign and pass laws in its jurisdiction on a given territory. So this is the mapping. And I would say that the general trend here is again, and it ties back to what we discussed earlier, who decides? In a democracy, governed with legislature and tribunals, who ultimately is able to speak about rights and freedoms? And the respondent generally will say, this is the province, this is the legislature. On these rights were allowed under the Constitution. And the main appellants will say, it's the court, it's the tribunals. These are the ones who need to make the decision. And I would say that's the breakdown.
Very good. Yuan, what do you make of that, and how would you characterize some of the main trends you're seeing in the positions taken?
I think Xavier is correct, and I have to thank him for having done this bit, because because the briefs are actually quite repetitive, and it does get boring after a while. I think the number of interveners is huge. I don't know if it's a record. I would not be surprised if it is. But the presence of interveners in large numbers is actually not atypical for charter litigation in Canada, right? Ever since the charter was enacted, activist groups have viewed the charter as a way of getting what they want if the legislature did not give them what they want. And the Supreme Court has adopted a very loose, extremely liberal view of who gets to intervene, right? Because in principle, you have to have a certain interest in the case, which goes beyond the general in order to be an intervener. And the Supreme Court in practice has applied such rules very loosely. So I've just opened the PDF of the brief of the Attorney General of Canada, and there are 3 pages or so, single space, of all the interveners, and some of them have obviously interest, which is concrete. The parties, obviously, I think the Canadian Human Rights Commission, the English Medical School Board, and so on. The Attorney Generals, obviously, and we are a federation, so we have lots of Attorney Generals. That's fine. And then you go down the list, right, and it becomes a bit more diverse. Shall we say? You have the Community Legal Assistance Society, the South Asian Legal Clinic of Ontario, the Laval Longueuil Criminal Defense Lawyers Association, and so on, right? And for a lot of these organizations, it's actually good publicity, right? You can raise money by saying, well, we intervened in front of the Supreme Court. Here's our guy, in a gown, making the same point which everybody else has made already. And I think this is really reflects the fact that the Supreme Court has become, in many ways, the place where controversial decisions are decided in Canada, right? Obviously, the legislature still makes laws, but if you lose in the Quebec National Assembly, you can relitigate this in the courts. This group knows this, right? Which is why they
Mhm.
invest a huge amount of money and effort in this. And frankly, I don't think this is a healthy trend, right? What the Supreme Court does, what every court does fundamentally, is to decide disputes between real parties, or in the case of reference opinions, to give a hypothetical legal opinion to the Crown. But for a court to really act as if it was a standing committee of the House of Commons, which I think is what we're seeing in this case, I think really reflects this very unwholesome, this very unhealthy culture we have in Canada, where we have elevated the judges and judicial constitutional reasoning above democratic reasoning. This is not to say that the judges are not very intelligent people for the most part, but again, I really want to emphasize this point. It's about who decides, if you look at the number of interveners, I think the people who are involved in trying to change policy know exactly who decides this case. Which I think is very unfortunate. And the last thing I will add is that in general, intervener groups tend to lean a certain way. They do tend to lean the way of greater judicial power, of a more expansive, a broader interpretation of the charter, and hack is no exception. Insofar as limiting Section 33 means enlarging the role of the judges, we are seeing exactly the sort of breakdown one would generally expect to see in terms of numbers. I mean, I didn't do the maths. I didn't do the arithmetic, but on the whole, I think most of the interveners, and especially most of the non-governmental interveners, are on the side of the challengers to the
Mhm.
law, and that is also something which is very typical of a charter litigation in Canada since 1982.
Those are excellent points, Joanna, and it's good we have a political science perspective like yours to draw out some of the broader implications, yes, of having such a strong court post charter. And we like to lament, I think, appropriately the lack of substance in the legislatures now, and you can see why. Yes, indeed, because the list of controversial decisions that are quite political in nature have been made increasingly by the courts, and this is one of the things we take issue with here at MLI. Anyway. And I want to move on to this because you alluded to it. Like, there's a lot of pressure that's been mounting around some of these controversial issues, and the use of the clause is where we want to go next. But first, Francois, if you could fill in any gaps here, and since you were participating in the hearings, what do you get a sense? It's not appropriate, I think, to read from the oral arguments, the tea leaves and which way people are going, but one can't help but do that. There were a lot of comments in media, and certain lines of questioning pursued by judges. So what can you say in that regard? Are there some standouts from what we heard in the hearings?
Well, I do not have a crystal ball, so I cannot make any predictions. But from my frontline opinion, I am pretty much certain that we are going to have a majority minority decision. This is going to end up as a divided case, probably a 4-3. Now, I will not presume to say who will go on which side, but I have a strong feeling that Chief Justice Wagner will be the arbitrator, will be the deciding factor between two other groups. I've seen basically there are two main, well, there are several issues, but two main points of contentions. First of all, the provincial powers when it comes to the power to enact laws by a democratically elected assembly versus the federalized, centralized power of the courts to unmake them. So that kind of equilibrium of power is questioned by both groups. The proponents of the Notwithstanding Clause are arguing that, well, in a constitutional democracy, the final word should be entailed to the legislator, not to the tribunals. And on the opposing side, there should be some limit, and the tribunal should have the supreme and final word. So let's see on how the courts will adjudicate on that. But I mean, I will, of course, plead my own case that I do think and hope, but also think that the judges are probably going to uphold the Constitution as is. And on that issue, there is another issue which I want to talk about. It's specific to Quebec, but from so far, what I've said applies to all provinces. But there's another issue just for Quebec. I'll get that. I'll get to that in 1 second. But we've discussed about the power of declaratory judgment. One argument that was heavily pleaded by many interveners and the Attorney General of Canada was that, okay, fine, the tribunals cannot set aside a law, but they should be able to render a declaratory judgment. A non-effective way for the tribunal to say that this law goes against the XYZ freedoms guaranteed by the Canadian Charter. Should they be able to do it? So on the opponents, on the appellant side, well, yes, of course, they should be able, because on their opinion, the Notwithstanding Clause only prevents the court from invalidating laws. But that's not the only way to read it, and the Attorney General of all the provinces, Quebec included, and many of the interveners on the pro-laïcité side, were quick to point out that at this level, a declaratory judgment would only have one single effect, a political one. It would not be part of the so-called dialogue theory, and that's another issue, because you can very well say that the dialogue has already been had, already happened at the National Assembly level, and the legislators said that the final word has been said. It's not an authoritarian use of power, it's just the dialogue is between the legislature and the civil society, not with the courts. But all that set aside, is that when it comes to declaratory judgment as a matter of judicial power, it's used to pronounce what law is. But when you look at the use of declaratory judgment in constitutional matters, it has always been used to direct government to act, especially in First Nation cases, when the court uses their declaratory power to find that the government has infringed on the honor of the crown, on a collective rights, on a rights of consultation, and or on many other matters, such as in immigration law, criminal law. When a declaratory judgment is rendered, it directs the government to act, to correct it. But here, it cannot have that effect. You cannot act and direct the government to unmake the law. The only effect it could have is a political one. And asking the judges to render a declaratory judgment would be akin to asking them to do indirectly what they cannot do directly, politics. And that many attorney generals have pointed out. And I think that several judges, even in their own remarks, I'm thinking of Justice Rowe, for example, did point it out. And there's the second point I want to address is that all I've said was applicable to all provinces, Quebec included, but all provinces. But there's also an additional importance between parliamentary sovereignty, which applies specifically for Quebec. Not saying that the other provinces cannot inspire themselves from that viewpoint, but for Quebec it has a special meaning because, and this goes from the beginning of Canada itself, before 1982, before even 1867, at the from the Act of Quebec 1774, at the very first days of British Canada, I see Xavier smiling, he knows where I'm going with this, is that Quebec, we have a distinct legal tradition. And a legal tradition is not just a big fancy word for where are our sources of law. We have a civil code, and no. It's a different way of reasoning. It's a different way to apply and interpret the meaning and how law works as a science, including in what are the respective powers of the legislature and the tribunals. Are the tribunals legitimate to enact social policies through their judgments? From a common law perspective, which is the main perspective of the Federation and the centralized institutions, yes, they are. But from a civilian law perspective, no, they're not. And that civil law perspective is constitutionally recognized since the birth of Canada, and it has been reconducted in the 19th century, and it persists as of today. And to give you a very, very contemporary example, as the different meanings that freedom of religion can take from a civilian or civilist, and a common lawyer perspective, because we are not the only society in the world that is dealing with laicity, right of religion in the public sphere. Take, for example, France or many other countries in the European Union. I'm thinking about Italy, Germany, Austria, Luxembourg. There are several examples of civil law jurisdictions which have judged, it has gone to their Supreme Courts that no, it is not against human rights as a matter of human rights to ask for civil servants that are representing the states, that are serving the citizens and vulnerable citizens that are the children at that, to ask them to not wear religious symbols in the course of their duty. Why? Because from a civil law perspective, there is a fundamental distinction between the religious belief of a person and the expression of those beliefs through, notably, garb and symbolism, which are interconnected but not fused. But in common law, the other legal tradition, which is the dominant centralized tradition of the Federation, those two elements are almost fused. And asking for someone to remove religious symbols to accomplish his or her duties would be kind of the same deal as asking a person in a wheelchair to please step up and not use a wheelchair from 9 to 5. Something completely odious and appalling. But those are really two ways of looking at things. And in Quebec, there is this legal tradition which sees laws with its own very legitimate set of premises and reasoning. And it also sees the use of the notwithstanding mechanism in and of itself with its own reasons and premises. And it was part of my pleading in front of the Supreme Court, but we have established, I mean, there are empirical numbers. You can look at the studies we've published on that. But over the past 40 years, Quebec has used the notwithstanding mechanism over 110 times, while in the entire rest of Canada, including all the provinces and the federal level, if my numbers are right, 7 times. We are speaking orders of magnitudes of difference. But in Quebec, it's part of a manner of seeing how the equilibrium of power works and how the legislature can actually use its legislative power for the common good. And it is noteworthy, and I'll conclude and let the others speak after that, but it's also noteworthy to note that in all those 40 years of using notwithstanding mechanism, the parliamentary sovereignty, Quebec has used it over 90% times to enact social progress for retirement regimes that would favor women that are employed of the state to take care of to take into account maternity leaves, to allow for the funding of agricultural reforms, common good always. And it's also very noteworthy to note that in 99.6, I think, I forgot the last fraction, but over 99% of cases, Quebec used the notwithstanding mechanism, parliamentary sovereignty, preemptively, upstream, before a legal challenge. It has only used it in response to a legal challenge once. If memory serves me right, it would be in 1988 under the Robert Bourassa second government when he used it to reinstate part of the Charter of the French language. One case, and over 110 which have all been used upstream. And in matters of constitution law, usage and the parliamentary usage and customs are norm generating. And we contend, and Quebec contends, that by using in a peaceful, public, and repeated manner the notwithstanding mechanism in such a way for over 40 years, it has created an acceptable theory and practice of the notwithstanding mechanism in Quebec that the courts should recognize, at least if federalism is to truly mean something.
Yeah, well, there was a lot in there, Francois. I just want to seize on a couple of things before going to declarations and then a few other issues before we can conclude, and those being really, I think your points about how rights are interpreted and how they jive with other rights is really what's at issue here. Like, they're not airtight boxes, and so they require interpretation. And that's one of the reasons why, we have interpretation from the courts, and we preserve the ability from the legislatures, and what a lot of the debate is coming down to here. And another thing, the question of declaration. So this is really interesting in that, in 2024 there was a major decision in Power by the Supreme Court, ruling that the state doesn't have absolute immunity from damages when it passes laws that are found to be unconstitutional. Now, were it to do, as you said, this kind of declaration without power to require, the government to act, which it would most certainly need to do, I think, to preserve the effect of Section 33. Is there perhaps a chance here that damages could be awarded, or that's where some people are hoping that this decision could go, if, as you say, it seems likely that the core of the opinion maybe to preserve the effect of Section 33, but give something to the other side, so to speak. And Yuan and Xavier, I'm keen for your thoughts on that.
Yes, I'm going to touch on Power in a second, but before that, I just wanted to perhaps very quickly defend the honor of the common law tradition. The tradition in common law certainly does, generally speaking, leave more leeway to judges to develop the common law, but this was always subject to Parliament being sovereign. This is the tradition we actually had in Canada before 1982. Right, parliamentary sovereignty is very much ingrained in the common law tradition. When Sir Edward Coke said that the common law could override Parliament in some cases, he lost his job, and that was and that was that. And of course, the Constitution Act 1867 begins with its preamble by saying that Canada should have a constitution similar in principle to that of the United Kingdom. And here, for most of the history of Canada, it was the expectation that as long as the very basic limits of divisions of power and so on in the British North America Act were observed, legislatures were more or less free to do whatever they wanted. This was the case in English Canada as it was in French Canada. So I don't want to necessarily leave an impression that parliamentary sovereignty is alien to the Anglo-Canadian tradition. In fact, it is essential to that. And I think it's good for Quebec that Quebec is is exercising its prerogatives, and I certainly hope that the rest of Canada rediscovers its common law tradition, which does really also leave the last word to the legislatures. Now, going to Power, I think Power is very interesting, right? Because what happened essentially was the legislature of New Brunswick enacted a law which affected Mr. Power. I think it was a criminal law. And the law was struck down by the Supreme Court, and then Mr. Power said that because the law was struck down, he ought to be awarded the financial damages from the Crown of New Brunswick. And the Supreme Court in 2024 opened the door to that. This touches really on the distinction between, what does the Section 33 do? Does it merely suspend the invalidity of the law, or does it constitute the legislature making, stating that the law is valid in a binding manner? Because, of course, if the legislature, by invoking Section 33, is making a final determination for 5 years that no rights are infringed, that this is the correct way of interpreting the Canadian Charter of Rights and Freedoms, then there's no breach of law during the 5 years. Whereas if you take the view that the clause is merely suspensive, then the law is being broken. It's just that the courts are prohibited from, acting against it. And obviously, the question is, what happens after 5 years, assuming that the clause is not renewed? And generally speaking, if we look at the track record of Section 33 invocations, I think in most, if not almost all of the cases it has been used, the clause has not been renewed. So I think, yes, given the very original, shall we say, jurisprudence of the Supreme Court since Power in that regard, I think there's a risk perhaps of the court coming up with a doctrine whereby not only is the use of Section 33 limited in terms of the courts being able to make a declaration and so on. But I think potentially, I think the logical conclusion, if the court does take this view of Section 33, I think the logical conclusion is, well, after 5 years, can somebody who has been wronged by that impugned law have any recourse beyond a declaration? Can he sue for damages? Can he, hold people liable personally and so on? I've seen some suggestions from some law professors, but generally speaking, it takes a few years before the worst ideas of Canadian legal academia, percolate down to the courts. I don't think I've seen any intervener being that extreme, although I might have missed something. But I think this is definitely a possibility going down the line if the court does really limit the use of the notwithstanding clause.
Right. Yeah. If I may add on this, I think Yuan's analysis is entirely correct, because this goes to retroactive effect, right? With power. So let's say you do have this law who's shielded from, or shielding itself from, application of charter provisions. After 5 years, becomes effective. You don't renew Section 33. Then what happens? Can you get damages? And we will only know that depending on what the Supreme Court decide in this case. Because if this case is not reaffirming the principle in Ford and explaining very clearly the effects of Section 33 and opening the door to declarations of inconsistency or potential inconsistency with an inapplicable provision, well, then it opens the door for coming back in a similar fashion as in Power and say, look, I've been harmed by this legislation for the time that it was shielded from Section 33, and I know this because the court has decided that there is an inconsistency here.
Yeah, no, I mean, that's certainly something to watch out for. I don't think it has been discussed, but it's certainly in the air outside of the case, and one could see it going that way. So I'm just going to make a couple of comments about the nature of rights and this question of irreparable impairment, and then turn to kind of what to expect from here. So you mentioned this, Yuan, that after the 5 years, if it's not invoked, what happens to the status of the law? There's some that would say that the way that Section 33 is worded, it's kind of an implicit admission that the law as passed is unconstitutional. There are others who are saying, no, in fact, it's part of this coordinate constitutional interpretation idea, wherein we're saying that, we understand and are concerned that the courts may, if challenged, rule a certain way on this law. And in fact, we may have a different opinion, and we're going to use the clause to shield it against a possible outcome. But it's really an exercise in supplementing the protections in Section 1, which is the reasonable limits clause. I wonder, if you have thoughts on that, Xavier and Yuan. And secondly, the nature of rights. I mean, again, I've alluded to this before, but people tend to, I think, assume that, at least non-lawyers anyway, that rights are relatively clear and straightforward. They mean this, and they're clear infringements, and that they're kind of airtight boxes, so to speak, and then so there isn't so much of a question of an interpretation here, and I guess I would just put some comments out there, like when we look at the text of the charter, like some rights are more narrowly circumscribed. They have tighter definitions. So life, liberty, security of the person, for example, it's narrowed by the phrase "except in accordance with the principles of fundamental justice," and the search and seizure power in Section 8 is limited to unreasonable searches and seizures. But arguably there is a great deal of is not a great deal of specificity about how they're to be applied, and certainly other sections don't even have that. So those two questions for you. What do you make of this question of a law's what does it mean to say that a law is invoked notwithstanding the charter, and what happens after it's if it's used preemptively and not reviewed, and is it, if continually renewed, irreparably impairing a law, and the nature of rights and how they're interpreted.
I'm going to address the second question mainly. I think, yes, laymen especially have this view of rights which is very straightforward, right? We have rights and they come from somewhere. In Canada, we have adopted this view that they really come from a piece of paper signed in 1982, and there was nothing before that. We lived in this terrible country with no rights, and then one day, Pierre Trudeau came back from London with a parchment, which is now, which gives Canadian rights. Beautiful rights are, like any legislation, are inherently written at a general level, right? Legislation is for the general, not the specific, in most cases, and the charters of rights, which have to cover the whole gamut of life, are by their very nature, they have to be vague and specific, both because you cannot foresee every single eventuality, and because you have to keep things vague so that there is a consensus, right? So had the charter being more detailed, there is a good chance that that Canada would not have a charter because nobody would actually be able to agree on the limits. Or if you had a charter, maybe it could potentially be a very short one. Saying things you have the right to vote every 4 years. Which are not that controversial. Although even then, obviously the charter says you can suspend, you can postpone elections using certain procedures. So yes, absolutely. You have to determine whether a right exists, but that is not the last step, right? You have to determine then what is the exact content, the scope of the rights, and then you have to determine does it interact with other rights and so on, are there any limits, and how and then how does this bundle of abstract political ideas and legal entitlements apply to the specifics of the case. And I would just say that it is a legal exercise in part, but it is also a moral and philosophical exercise. And it's not really obvious that judges are any better than, say, philosophers or ethicists in doing so, right? The task of a judge is constrained by the nature of legal adjudication. You have a dispute, you have the laws, are traditions, canons, of rules about how you interpret the legislation. But fundamentally, its interpretation of rights is a much richer and much more ambiguous, ambivalent exercise, which really goes beyond the scope of what the judiciary is able to do. And that is why I think, and I think we have some sort of agreement here, that it is perfectly legitimate for legislatures, which are representative in a way which courts can never hope to be representative, which are legitimate democratically in a way which courts can never aspire to be and should not be. Right? Courts are not meant to be democracies, and I think it's perfectly fine for this cross-section, this elected representatives of the political community, to take a view which goes beyond what judges are able to do within their moral framework. But unfortunately, in Canada, we have this myth that rights come from this one document and judges are its final guardians. I think in many ways it is a failure of civics, of civic education. But I'll just leave it at here.
Mm.
If I may add something, so I agree with what Yuan said. And when we say that rights are vague, what we really mean here is that they are of general content, right? They are at a level of generality which allows for a broad range of specificities. And then the job, and I agree, it's actually not that much a legal exercise. What freedom means, freedom of speech, freedom of religion, this is this goes more to a moral exercise or a question of philosophy of law here, and this goes to the core of everything that the core of the legal the core of the legal question, I would say, is a matter of determination. We need to be able to take um, general content, general notions, and apply them to specific cases. And it's only in the specific cases that we are truly able to identify whether the freedom per se, or the freedom is being well exercised and upheld and conformed. And so that's and we have the same debates. I was involved recently in debates about whether we should do textual analysis or common good interpretation. And a lot of people are always saying, well, the common good is undefined. It's of general content. Well, what is the common good, and who decide what that is? It's the same thing. It's the same thing with rights and freedom. It's always the same question. And that's why we're in a democracy, and that's why we debate these things. There are no clear answers to that. But our task at hand is being able to say, on a given specific cases, what are we doing with that rights or freedom? Is it important for us? And if so, yes. And how does it compare to the other rights and freedoms that are important to us? And we need to be able, as a people, to do this assessment and come out with a conclusion. And within the realm of reasonable disagreement, these conclusions may be for Quebec different than in Ontario or in Alberta or in BC, and that is perfectly fine. So this is why we have Section 33, which allows us to do this assessment collectively and keep our democracy healthy.
Okay, well, I'd like to keep plumbing the depths of
If I may.
Yes, Francois, I'd love to hear from you in our final remarks here. And so, really, I want to look ahead now to what you foresee may come of this. So, what are the different permutations of the rulings we could expect? What do you think policymakers should be prepared for? And also, regardless of the outcome, I think what can be done? Are there legislative responses, even constitutional reform, institutional changes that could restore a better balance between the courts and legislatures? I'd love to hear from each of you. Francois, why don't we start with you?
As I said, I don't have a crystal ball, but I do think that we are going. I mean, it is my belief and hope at the same time that we're going to end up with a majority judgment that will uphold the notwithstanding clause as is with no declaratory judgment. I do, however, think that there is a strong possibility that the dissent, the minority, will have their declaratory judgment in their own dissenting motives, and all that will make history. But I do think that we are going to see the parliamentary sovereignty to be actually upheld here, because as my colleagues stated right before me, everybody agrees that all rights, but fundamental rights all the more so, are drafted in broad terms. And it comes to individual cases to adjudicate them individual meaning. Of course, that's the role of the courts. And just to make a quick parenthesis, I do want to respect the originality and the ingenuity of the common law. I'm not saying that there is no parliamentary sovereignty in common law. I'm just saying that both legal traditions function in different ways, just for the record. Now, to get back on that, there is one question, though. To what extent do the courts have the power to make rights evolve in their nature, in their scope, in their reach? It's one thing to say the courts are going to apply the rights to equality, freedom of expression, freedom of speech, freedom of association to XYZ case. But what happens when they broaden the meaning of a right from case to case to case in a process that takes years, decades, but has an effect nevertheless? If we are looking to the motives of equality, for example, under Section 15 of the Canadian Charter, I would be impressed to find a historical source from the constituent in 1981, which were talking about gender equality, pronouns, and LGBTQ plus rights in the 80s to be seen as analogous rights to those explicitly listed in the text of Section 15. I'm not saying it's a good or it's a bad thing. I'm saying that we are seeing that the tribunals, from case to case, are actually taking a policy power by attributing meaning to the rights which are entrenched in the Charter. And here is where two visions collide. Is the fundamental meaning, the object of the rights, something which has been set by the initial legislator, the initial constituent, to which the court has towards which the court have only a power of application? And if we want those rights to go further, for example, should we include artificial intelligence as persons at some point? That question will come in our lifetimes, gentlemen. But is it to the legislature, to the elected representative of the people to adjudicate that right should mean and include that? Or does it fall to the tribunals to actually determine that, yes, this right actually includes that when it was not part of the original draft? Two theories are actually at odds with one another here, and we're trying to strike a balance. And it's going to be interesting to see in which way it's going to evolve. And here I see on the short term, if I'm wrong and there's an overturning of the Notwithstanding Clause, I have already forecalled, and I will forecall it again. If that happens, we gentlemen are going to have a constitutional crisis on our hand, one that could very well have consequences for the very existence of the Canadian Federation, because it will fundamentally alter the balance of power between the federal and centralized institutions and the autonomy of the provinces. And I will make no predictions as to where it will go from there. But other people are also asking for reforms, and those needs to be heard. Now, is the Canadian Constitution actually reformable? That's a highly theoretical question. It has been attempted lots of times, and more often than not, it is a hard stone to carve, let's just say. But speaking in pure theory, one path that could be envisioned, and that would actually ask for the federal powers, for the centralized powers to put a lot of water in their wine, if you allow me the expression, would be, could we have a Supreme Court of Canada whose jurisdiction would only be limited as a Supreme Appellate Court with the power to invalidate law, whose jurisdiction would be only limited to matters of federal jurisdiction, with each province having its own supreme constitutional authority with its own Supreme Constitutional Court? That is something which is discussed more and more, and I may be optimistic, well, from my perspective, but it is a way of addressing the future of Canadian constitutionalism that we may see in the following years of decades. Actually, one of the many futures of the Constitution of Canada as a federation or otherwise.
Very interesting. Thank you, Francois. Juan and Xavier, what are your thoughts if we must speculate?
I also don't want to look foolish by predicting things which are fundamentally unpredictable. The Supreme Court is, by its very nature, untransparent, and its cavalier attitude to precedents means that it is even less predictable than ordinary courts. I think the fact that the case came from Quebec and that it touches an issue of great political cultural salience for Quebec probably will make a bit of a difference, right? Had the test case been the Saskatchewan transgender case, I think we would be in a different situation. I think judges would find it very hard, coming from the social medias they do come from, to perhaps uphold the law in its entirety. Whereas the fact that the challenge really came from Quebec does, I think, give the Supreme Court a way out. Right, the Supreme Court is nothing if not political, and some of that might mean that the court will not want to be the guilty man in the breakup of Canada. I do notice that when when Julius Gray, who appeared for once intervener, said something like, "Oh, Anglophone Canadians are much more diverse." The Chief Justice Richard Wagner got very angry and said, "We French Canadians are as diverse. How can you say that?" So I think and I think I certainly do hope that the Quebec angle will make a bit of a difference. And I totally agree with Francois that if this case goes the other way, I think we have a full-blown old-fashioned constitutional crisis in our hands. I note en passant that there are Quebec elections this year, and that the Parti Québécois is on the cusp of a majority. That seems to matter to me. I obviously want Canada to continue, and I speak as somebody from that point of view. Now, on the question of reforms, I'm actually not convinced that the way to fix this problem is to do institutional tinkering, right? So let's imagine that the Supreme Court becomes a court of limited federal jurisdiction. That's very possible. Other countries have similar arrangements. In Scotland, for instance, the House of Lords was not supreme in criminal law. Even within the common law tradition, broadly understood, you don't necessarily have to have one Supreme Court as the final authoritative lawgiver for everybody. Okay, every province has its own highest court of appeal, and provincial governments get to appoint judges. The judges are still going to come from the same class. They still will have attended the same law schools. They still will have learned the same doctrines, the same ideas, being doctrinated in the same tradition, which has led us to this total mess. But we'll just have 10 times more of that mess, as opposed to it being concentrated in Ottawa, which, as it happens, nobody really likes, so we can blame Ottawa. I think what has to change really is something more fundamental. We have to rediscover in Canada the proper meaning of rights, the proper meaning of democracy, the proper meaning of constitutionalism, right? Because if you simply do tinkering on the institutional side, you end up with the same problem, because we have lost, I think, our capacity for self-governance, because we have decided to outsource it to a cadre, to a caste of philosopher kings whose main distinction is that they went to law school and did it very well, for the most part. It's been the case for 40 years. So I think if you go back to the early 80s, every warning against a charter, many of which actually came from the left, from the labor movement, became real. And we have lost something very precious, which is the ability to self-govern, to have proper debates without saying, well, what does this piece of paper say? What will the 9 wise men and women of Ottawa say? And so I think really, I hope this case goes well. I hope the Federation stays intact. But I hope this will be a wake-up call for everyone, especially the provinces which are not Quebec, to reassert themselves. And part of that actually could just be using the Notwithstanding Clause much more, right? When the Constitution, the 1982 Charter came in, Quebec used Section 33 for every act of the Quebec National Assembly for I think 7 or 8 years. I'm not suggesting that you do that in every province. I'm saying that there's no reason why the Notwithstanding Clause should be considered a Quebec special. It is very much in the tradition of the best traditions of common law constitutionalism. It is part of our common shared intangible cultural and legal heritage, and we should use it more for a start.
Right. So again, I will not also try to, speculate on what exactly will happen, but here's some consideration we want to have. So first of all, I think one of the key part of the judgment and the work that the judges need to do is about stare decisis. And by that I mean, what does the decision in Ford means? What is it authoritative on? What it says and what it doesn't say? And do we need to differentiate from Ford, or do we need to clarify Ford, or do we need to fall back exactly on Ford? So I think that's one of the key part here. The reason why you would want to differentiate is based on the facts and what Ford has answered, and but then you might also want to clarify and say, because 4 doesn't say explicitly, it doesn't talk explicitly about judicial declarations. So we will need some type of commentary on how that fits in within the precedents of the court and where we're going with it, most definitely. Another thing that I think we need to consider that I've seen go around is that Judge Martin is on the bench, and I don't think she's there for that long. I think she's there until the fall, and
November
after that,
30th. November
yes,
30th.
November,
Yeah.
exactly.
That's what
Thank
we
you
heard
for
before.
the exact date. So what does this mean? This means either we get the case with Martin signing before that date, or she leaves, we don't have the judgment, and then it opens up the door where the UR against Pride and Saskatchewan case comes in, and maybe they want to decide the two cases together. I don't know. But there's a decision to be made here. And this, if I look at the mapping of the judges, it may well be, to Francois's hope, that you have 4 judges, upholding the Quebec Court of Appeal decision, but then remaining 3 are not will be in the dissent and not following. But if Martin drops, and based on what she has said in different cases before, then it might become 4-2. So I don't know how this lines up, but this is most definitely a consideration as to how the motives will be written, the reasons of the courts will be written, and who will be signing to what. And then and one final consideration goes back to what we have described about the legal culture in Quebec against the legal culture in the common law and the practice of the court, because I think Quebec is not that used to this way of doing things, I will say, because the way the civil law works is that you have a corporate body, and the corporate body is the legislature, and we get together and we debate and we pass laws on a general level, and we discuss the specifics. And the way the common law works and has been working historically is a little bit the opposite. They pick up on a specific case, they bring it up all the way up to the superior tribunals, and then they add 1, 2, or 3 of these cases together, and then they decide what the general trend is. And this is how you get precedents. So there's a tendency in the common law tradition to go through the courts to, basically legislate these issues. Whereas the civil law tradition doesn't work this way, has never worked this way, and this way of working is a bit foreign to them. And so I think there's an opportunity here for the Supreme Court of Canada to recognize that, and maybe without deciding on the very technicalities of the debates of the effects of Section 33, fall back on basically what the Quebec Court of Appeal has said and say, look, Section 33 has been invoked for a long time. Every single time we have kept our mouths shut. We have considered ourselves to be tied on this issue, and this is a past practice of the court. It's not a legal argument per se, but it goes to the customary approach of the court as an institution itself within Canada, and it goes to its own behavior. And maybe they don't want to break with their own behavior. Maybe they want to go the same way they always been when Section 33 is invoked. And so all of this taken together, I'm hopeful that they will uphold the real meaning of the Constitution, the real effect of the Constitution, as it was negotiated and constitutionalized. But ultimately, we'll see what happens. And if they do end up deciding that Section 33 is, as we say, that is exclusive and complete in its effect, and there are no limits on it, well, then I wouldn't be surprised in a few years that someone in these legal circles come back with the idea of disallowance. And, because now there's this tool which can be used. And if we're going back to tradition and customs and all of these ideas or this pathway, well, then the notion of disallowance may come to the surface. And I wouldn't like that. And selfishly, in my own perspective, for sure, I think that would be a huge mistake. But I can't really, just disregard this legal tool as if it has never existed, and that may be the only remaining tool for a common law perspective to achieve through the courts, or even through the executive, actually, something that they weren't able to achieve here.
Yeah, well, what is clear is that there is so much at stake in this case. So it's unsurprising it's attracting the attention that it has. And really, you alluded to the fact, many of you, I think that though it is being used most often in Quebec, the rate of its use is increasing because this points to a trend of concern with the types of decisions that the courts are rendering. And I do, for one, think it's salutary as Yuan hopes that the legislatures will be reinvigorated and made to be more substantive in their debate. And I think the Canadian public to care more about law and their passage. And I think we see some signs of this in all of the attention that this case is getting, in the media, and across the electorate in Canada. So whichever way it goes, I do think we've reinvigorated the debate in a healthy way. And so I want to thank each of you for coming. Je suis désolé qu'on n'a pas parlé beaucoup en français, mais j'espère que c'est disséminé là-bas dans la belle province. Et je vous remercie pour nous joigner. And
Merci beaucoup.
yeah, and I'll just say, if you enjoyed this conversation, please do like and subscribe to our channels. And for the Macdonald-Laurier Institute, I'm Peter Copeland. Thanks for listening to Inside Policy Talks.